story to share too.
Which one?
Welcome, everybody. Excited to have you in class today. My name is Carrie Thottner. I'm the Chief Learning Officer here at the National Constitution Center. So today's class is going to dive into the First Amendment, and we're going to look really closely at the First Amendment and then laser focus in on free speech. Today's class, we have a guest scholar joining us today for our class at 2 o'clock on a Wednesday. His name is Nicholas Moskowitz, and he's one of our internal constitutional scholars at the National Constitution Center. So Nicholas, great to have you back on the Wednesday session. Some of our students that have come before know you, and a lot of our students are new. So everybody, welcome and meet Nick. So excited to have you, Nick. Nick knows, and he's used to working with me, so he knows I'm gonna ask him 8 million questions. But as we go through class, if you have questions too, feel free to put it in the chat or the Q&A, and I'll make sure I pull them from there and get them to Nick. But I'll kick off with my questions. Nicholas, I'd love to know more about kind of what was the genesis of the First Amendment. So we'll start pretty broad with that First Amendment. And, you know, so many times when we're talking about this with students of all ages, it feels sometimes like it's a little bit of a grab bag. There's lots of these different freedoms that don't always feel connected in that First Amendment. So maybe we start there with the First Amendment, and you can help kind of show us why they do connect and why they do overlap, and sometimes how they keep them separate and how they connect them. The second question, when we dive into speech, is we want to look at a couple different periods in time and people that have either expanded or contracted that speech and some court cases. So I know that doesn't sound like a lot, but I know this is going to take us easy the 30 minutes. So why don't we kick it off in my beautiful color-coded First Amendment? Could you walk us through this First Amendment and give us some key pieces of it, the different clauses, and how and why they're together in one amendment?
Sure. And I think as we talked about at the noon hour, it is a bit of a grab bag, but there is a thread that runs through it. It's a grab bag in the sense of, as I said at the noon hour, James Madison's original drafts of what would become the Bill of Rights. His Fifth Amendment included what he thought were the 3 essential freedoms that the states couldn't infringe upon. He listed the right to jury trial, freedom of the press, and the right to conscience. That's the key thread. Now, you know, looking at this, that's not what ended up happening in the Bill of Rights. And really, multiple draft amendments got put together into what became the text of the First Amendment, because that freedom of the speech and press had been separate from the religious freedoms. But we ended up with this all-inclusive First Amendment with these 5 freedoms. The thread that runs through them is the right to conscience. So we'll get to that. Let's run through those 5 freedoms that Curry has highlighted for you. First, by starting with what the key is, we're talking about the government. Congress shall make no law. This applies to the states. It does through the 14th Amendment and what we call incorporation. First Amendment has been incorporated over the course of the 20th century, but originally we're talking about Congress. But the point is really it's the government that has to act. We're talking about making laws. And our 5 freedoms are what? The establishment of religion or prohibiting the free exercise thereof. That's the religious liberty clauses. Or the abridgment of the freedom of speech or of the press. That's the focus here today. The right of the people to peacefully assemble, which say also includes the right of association. The key here is to keep in mind how these freedoms can actually work together sometimes in concert, that assembly and association can also include claims to speech or religious liberty. And then finally, the right to petition the government for redress of grievances, which was among the ancient rights of English liberty that wouldn't even pass the English Bill of Rights of 1689. This freedom to petition the king originally was an important ancient liberty. So that's all there in the text of the First Amendment. As I say, the heart of this that pulls the thread together is this freedom of conscience. As we have here this quote from James Madison: "The right of conscience and opinion must equally and completely accepted from government regulation when we say consciousness, what we're talking about is the right to one's thoughts and beliefs that cannot be alienated to government. That is, those inalienable, unalienable rights, meaning they can't be given away to government. And this was because that freedom of conscience was among those natural rights spoken of in the Declaration of Independence that were pre-governmental rights that are afforded to us by virtue of our creation and existence. And therefore, conscience rights could not be given away. Those were amongst the essential rights of all. And so that's the thread that runs through the First Amendment. I will stop there because I know we want to get to cases. We have to first start with 1798. So let's make a bridge to that.
Yeah, and just one beat before we jump from that. I love this. It always reminds me of a philosophy class when we do this part, because it reminds me of like, you think therefore, I think therefore I am. It's this idea that you have ideas that pop up and percolate from your brain, and therefore that's your right of conscience, and you can't control them. Therefore, no government can control them. And they're associated with who you hang out with, what you believe, what you don't believe, what you say and what you think. But as we dive into looking at freedom of speech in the press, real quick, as we clarify, and dive into that, when we talk about that, what is freedom of speech and what's covered? So that's the big question. What's covered in speech and press, and what is not covered in speech and press, before we dive into the history of understanding? Because it's not just what I'm saying, and it's not just what's in the newspaper. How is that a little bit more expansive than just talking?
Yes. It's expressive. It can be all sorts of different things, as you suggest. It's not literally just printed text. It's not just vocal speech. It could include not speaking. We have cases about the notion of what we would call coercive speech or coarse speech. That is, the First Amendment entails a right to not be forced to say you believe certain things. That comes out of the 1943 case dealing with the state laws mandating saluting the flag and saying the Pledge of Allegiance. That went to both religious liberty, but also freedom of speech, in the sense that it was a right to not say things. Here we have that picture. We're going to get to the Tinker case towards the end of the class, but this is expressive speech, and expressive speech covers things like wearing an armband, but it also includes things like flag burning. Flag burning was protected by the Supreme Court, most distinctly in a 1989 case, is part of an expressive speech. That is to say, conduct, expression, those things are also part of it, right? It includes things like wearing a jacket with an obscene phrase in opposition to the draft during the Vietnam War. That was also protected. So it does also entail things that are not just speaking and printed word, which is why, by the way, of course, also why it includes things that you share on the internet. And it could include just pictures themselves and express an idea, right? So artistic expression itself is also under here. So I'm not trying to get to every different thing. I'm just trying to suggest that there's an expansive idea of expression within it. So that's why when we say free speech, we often also hear the phrase free expression, right? First Amendment expression, right? And so that's meant to entail all these sorts of things that fall under the rubric of free speech in the First Amendment.
That is awesome. And everybody's doing a great job sharing other examples in the chat, so don't worry about it. But the flip of that, what is not? And Anna is getting extra points today for asking the question. It was like, I planted you, Anna. Is Colin Kaepernick taking a knee protected by the First Amendment? Yes or no, and why? So what's not protected by the First Amendment? And Anna, that was the number one question and conversation we had when many football players and basketball players and other sports players took a knee at a professional game. Where does that fall in this idea of the First Amendment? And Nick, go for it.
Right. So, I mean, the answer is that if the NFL, the NBA, any other private organization could freely punish their players if they wanted to, or uphold their freedom to do so, the question is a private one. It's not a First Amendment question. So,
because
what it really
they're not Congress.
They're not. Yes, they're not the government. So, the question is one more of what we call a culture of free speech or censoriousness or something like that. Whereas to say what we're really asking is free speech in the First Amendment, it's distinct in America, not just because of how much we protect, but because it's also a cultural value. And so there tends to be confusion in part because all Americans seem to know their First Amendment rights, and it gets imputed into these other conversations. The other thing worth noting is that sometimes it is blurred when companies are public utilities or they seem to have particular market power. And what that does is it highlights one of the key First Amendment debates right now, which is about the censorship in big tech. And what, if anything, Congress can do about it. And I'm not seeking to answer that question because we can't do that. It's a very complex set of questions, but it is to say there's a reason the First Amendment comes up there. And it's because a lot of people will say those tech companies get to choose who gets to be on their platforms because they're private companies. And there are others who will say, but there's a public interest there precisely because of the size of the company, but also because they have a public marketplace of ideas they are hosting. And it's not truly private in that sense. So what is the right answer? We can't say.
But I love all of this. I'm sorry, we feel very existential today, but that's the First Amendment. There is this overlap in this idea of the freedoms in the First Amendment. And then when we laser down into speech, there is that push and pull, that yin and yang of what we believe, what we know the constitutional First Amendment questions are. But at the same time, what Nick said is like, what's the value we hold as people in this community, this society, and this country towards freedom of expression and free speech? So Anna, that was a great question because there is an interplay in some places. Sometimes it's separated, but when you talk to people about these topics, you're going to hear both sides. You're going to hear their personal values and their American values on free speech and the constitutional question. So we narrow it down and say, let's focus first on the constitutional question, but with free speech, you can't get away from the values. They're so interconnected, which is why it's my favorite class to have this conversation in. So let's do the time walk now, Nick. And so let's go from 1789. So tell us one hot second on, the original Constitution doesn't have the First Amendment in it. We get it ratified with the Bill of Rights. Real quick timeline, and then bring us to its first test in 1798. Let me get the year right.
Yes, and I think the big picture, big idea here is this is not long after the Constitution's been ratified and the Bill of Rights has been ratified. We're talking about years after ratification of the Bill of Rights, 7 years. So this is really the first major test of the meaning of the First Amendment. And the context is that the 1790s is one of the most contentious periods in American history. There rising partisanship and division, the birth of the first party system. There are a lot of issues in that early America, and for those first Congresses to deal with. Foreign policy is one of them. They're fighting about taxes. They're fighting about Hamilton's Bank and the meaning of the Constitution and how much power the federal government has. But also their old ally, France. Well, they've had a revolution and now they're at war with Britain, our old enemy. Yet Britain isn't quite our enemy because the Washington administration signed a treaty that opened up a commercial relationship with them. The Jeffersonian Republicans, that political party, they didn't like that treaty. They didn't like the British. They preferred the French. The Federalists, John Adams, the second president, he's a member of the Federalist Party. They preferred the British. And that's one of these big party splits. And part of this new party system is these partisan newspapers. And when we say partisan, what we mean is that the parties themselves, they created the newspapers. The newspapers were a vehicle for them to express their partisan viewpoints, and they were open about that. And so the Jeffersonian newspapers are printing scandalous things about Adams. And Jefferson is his vice president, but he is the head of the opposition party, which is its own separate, fascinating subject. And so that's the context of creating this act, the Alien and Sedition Acts, which is, there are multiple acts. The Alien Act has to do with limiting immigration because it makes it harder for immigrants to become naturalized citizens. It increases the length of residency from 5 to 14 years, and it allows the president to freely deport immigrants who come from enemy countries, essentially. The Sedition Act is what has to do with speech. And it says, it basically targets false criticism that undermines the government. Now, that's a pretty open, broad category. The Federalists who wrote it thought clearly that even under the First Amendment, this was okay because they believed in an old concept of what we would call seditious libel. Essentially, they just thought this was one of those categories that was an exception to the First Amendment, particularly time of crisis, that the government could regulate. The Jeffersonians, Jefferson and his main ally, James Madison, they thought otherwise. Pretty much all of those who were imprisoned under this act are Jeffersonian Republican newspaper printers. They said, look, this is partisan, but also it's unconstitutional. So we have the Kentucky and Virginia resolutions in 1798. These are state legislators who are that are passing these resolutions to convince other states to join them in protesting this. And Madison makes the bold constitutional argument here. And he says the First Amendment clearly prohibits this action. And the reason is because the heart of the First Amendment is not just the right to conscience, because that's clear, but it's also the right to criticize one's government. Because his point is, if the government we've created is a constitutional democracy, a representative democracy, based on popular sovereignty, that is, we the people created this government and hold ultimate authority, then the right to criticize one's government and leadership is essential. Without it, everything else falls. And so that was Madison's crucial insight, is that, in fact, part of the First Amendment must be this right to criticize. We didn't necessarily agree to this earlier because people had different views 1787, 1789 concerning the limits of free speech, but Madison was articulating this important principle. And so that was his argument against the Alien Sedition Acts. Ultimately, Jefferson would become president 2 years later, and Jeffersonian Republicans would take over Congress. The acts would go away, and those who were still in prison would be pardoned by Jefferson. That was sort of the end of this particular constitutional crisis, or question, I should say. But it will come up again in 1918. That's the next thing we get to, but I'll leave it there because I want Curry to bring in any questions we might have.
Yeah, so great. I love the story. Talk about frenemies. There's so many good things on this, but Angelique brings up a great question. How do you and who determines if they're undermining the government or just speaking? And I think that is a recurring theme in all of these cases that we can look at and analyze. With this case, I mean, in simplest put, if you were picking on Adams, you were undermining the government. If you were picking on Jefferson, you weren't undermining the government. But that leads us perfectly into the Schenck case and other cases that I wish we could talk about, like the Whitney case and others. How do you know it's undermining the government? So tell us the story about Schenck and this case, what's going on at the time, that it's an anti-war protest at the Capitol. But again, back to that question, when is it speaking out and saying what you believe, and when is it undermining the government? And what did they think in this kind of snapshot and moment in time?
Well, I think that question gets to why Madison was, when he wrote that argument, he was doing it in terms that made this seem like it was deeply concerning, right? That this could erode constitutional protections if allowed to go forward, is because he thought, well, it's arbitrary trying to pick what is undermining, what isn't undermining, because it's too broad. In other words, the act itself, the text was far too broad. In other words, it prohibited way too much speech, right? If that makes sense, that's the best way of examining it. Schenck, I can't say it has the same problems now because we don't articulate a view that way, but is a matter of history. Look, the Sedition Act came back. It came back 120 years later, along with what was called the Espionage Act during World War I. When the United States finally entered the war, President Wilson in Congress passed a number of bills, including a draft to create a 2.5 million man army. This was a huge expansion of the military and the government generally. And the opposition were mostly socialists and communists who thought were not interested in a European war or the conscription of what they saw as their labor. And so they put out pamphlets and launched a campaign to oppose the draft and essentially said, hey, if you're drafted to be in the army, here's how you can get around it. Here's the arguments can you make against it. And they included constitutional arguments why they thought it was illegitimate and unconstitutional. They put those pamphlets out there. Well, the Espionage Act said you couldn't take actions that essentially would aid foreign enemies of the United States or inhibit actions of the military and the government. And so they were prosecuted for that under the notion that those pamphlets were asking people to take actions that would harm the war effort. And the Supreme Court upheld it. That's what the Schenck case is that, yes, that prosecution, that's okay. Why was it okay? And why was it unanimous? Holmes and the court said essentially, well, look, Congress has power over war, right? They have the war powers. They can declare war. They can create the army. They can regulate it. They do all those things. And in this time of crisis, if there are actions that will interfere with those powers, Congress has some ability to regulate that speech and conduct. It's called the clear and present danger test. So I know Curry's got a slide to show you the particulars of it. But as I suggest, the notion is, look, at the words or conduct are such nature as to create a clear and present danger that will bring about the substantive evils that Congress has a right to prevent, then they can limit that speech. And as I say, that's trying to connect it to those Article 1 powers. Now, Holmes, in a case that same year, a different case in the Abrams case, would say something that seemed a little bit different in a case that had to do with the Sedition Act. And this was pamphlets that were dropped in Brooklyn by communists who said they opposed the war in Russia. So this was after the 1917 Bolshevik Revolution. The United States had entered war against Russia. They were protesting that. And now Holmes here dissented. The majority of the court said that it was okay to arrest them too and to prosecute them. And he said, well, no, this is just speech. They're just advocating ideas. They're not trying to interfere with the war. They're just saying it's wrong. And then he articulated a theory of the First Amendment, which is now a pretty common idea of what the First Amendment really means, the heart of it. And he said the best test of truth is the power of the thought to get itself accepted in the competition of the market. It was the marketplace of ideas notion of free speech and expression that came out of this series of cases concerning World War I. And as I say, that Holmesian notion of the marketplace of ideas, followed by Justice Brandeis's idea of the First Amendment demands more, not less speech. Those ideas really, as I say, have had a lot of power going forward in terms of how we understand the First Amendment.
And that's what I think is so much fun about these court cases, and watching the almost like you're watching their brains ponder this question and ponder these moments over court cases in their opinions and in their dissents and in their concurrences, all the different ways they write about an outcome of a case. And you get to Whitney versus California, and you start to hear Holmes say, you know, opening up the marketplace and letting a lot of competition happen is the best way to get good speech. And Brandeis saying, I got a little bit of a different theory. I've got this theory that, you know, it can bubble up, and the idea that speech can bubble up, and that the only way to stop bad speech is by more speech. You start to get this, what we consider a much more modern conversation around free speech, and why we're so protective of free speech in this country is because we're based on it. But when you read these opinions, concurrences, and objections in these cases, you watch their kind of mindsets change, evolve, and also are, you know, almost articulate themselves better and better. So
well, they're articulating a theory of the whole First Amendment, exactly. Right? Love
it.
That's what you see. You said philosophy at the beginning, and that's kind of here, right? Is that, and Brandeis is also telling you something else. By the way, read that last 3 words: not enforce silence, which we started at the beginning, reminding you that the First Amendment isn't just speech, but something like the government can't enforce silence, but also silence itself could be speech. It depends, right? Because it could be a form of that first part, which is the purpose of speech is to reach what? Truth, and to expose falsehood and fallacies. The method by which that happens could include something like silence.
And the only way we test things is to almost like get it out and to share it, even if it feels wrong, and to test it at times.
And this is precisely why we have a culture of free speech and expression that goes along with the First Amendment, is because there is an agreement of these kind of things that Brandeis is talking about generally, that we're trying to find or discover truth, and that's at the heart of the First Amendment.
And I love that freedom of conscience is all about finding or discovering truth.
Yes,
now, what comes along with that, and I remember we interviewed Justice Kagan on this, and she's like, you know, it sounds beautiful when Holmes and Brandeis talk about this, but the reality of it is that we wind up protecting speech that we don't like a lot as well. That's ugly and gross, and things that you don't make you feel so romantic as these two made you feel. And that really nicely leads us probably into the last case of this class, which is we protect this kind of speech too. So tell us about the Brandenburg case, the story behind this.
Yeah, so exactly as you say, it's an example of what I like to call low value speech, right? That's sort of what First Amendment scholars would call it, right? Is there's this high value speech we're kind of talking about, as you just said with Holmes and Brandeis. Look, there's this set of really principled, important ideas that we're putting out there and competing, but it also means it includes the speech and expression that most people would consider bad. Here it's 1964, and it's a Ku Klux Klan rally in Ohio. Local TV showed up and recorded the chapter leader giving this speech, imploring the KKK members to march on Washington and do something about the corrupt leadership that was bringing down the country. And he was prosecuted under state law for incitement. What the Supreme Court said was, look, the speech had some violent rhetoric in it, and very much ideas that would be rejected by most people. But on the other hand, it was very vague. It did not say when, who, now this is going to happen. In other words, there's a lot of violent political rhetoric that is also acceptable under the First Amendment. The particular standard is, in order to prove incitement under the First Amendment, you have to show three things: that it's directed to an unlawful end or violent end, that it is going to happen right now, that means it's imminent, and it's likely to happen. And that is hard to do. And as we say, therefore, we generally protect speech unless it meets those three elements. Immediate lawless action. It's very hard to meet that. And so that means 50 plus years later, we've had decades and decades of building upon this Brandenburg notion of highly protective, right? Is that the government has to prove and meet a very high bar generally to regulate even a bad or violent rhetoric in speech.
Nick, that's a really high bar. And again, going back to what Kagan said, what they say about this open dialogue of speech and to get to better thought, better ideas, and better action is wonderful. But when you do that, you have to protect all speech, even the speech that you dislike or detest. One question as we wrap up class today, and students, if you have any questions, feel free to make sure they're in the chat now. But what are some of the cases coming through the courts right now that we should be paying attention to, that we might see come through around speech? Are there any in the courts right now that we'll see in June that we should be watching?
That's a First Amendment case. The one I can think about comes out of California. There's a series of cases that have to do with anonymous donor, whether or not they should be protected, or if the government should be able to essentially get lists of their members and their donors that would then be publicly exposed. And so that's a question of whether or not, or to what extent, the First Amendment protects anonymous speech as a form of expression and is part of the right of association, which again, by the way, is again that thread that connects both assembly or association with speech itself. And so I think that will be an important First Amendment case. I'm not sure that there's another one on the docket this year. The big one last year, of course, was the cheerleader case that had to do with speech in public schools, and the degree to which technology may affect the First Amendment's.
And then just protection. One more real quick follow-up question on this bar that we have. Two of our students asked, Terlissa and Ryan, let me just make sure I can find the question. Is this why when January 6th panel, there were so many challenges to the questions around January 6th, is because this threshold is so high that when we look at this case, we talk about it's in Ohio, and they're talking about going to the government in DC. It's really far away. There's no way they're going to be like, okay, let's storm the castle. Is this some of the pieces that came into play when understanding January 6th and the implications?
Yeah, well, so I had a First Amendment class yesterday, and I got a similar question. The answer, I think, there, without saying too much, because again, we don't tend to give we don't give political opinions here. But yes, indeed, it made it more difficult, including for impeachment, precisely because there are claims to incitement is a rhetorical claim, and then there's a legal definition of incitement. And the lawyers associated with that, of course, wanted to be careful to not use the legal definition of incitement. The reason was that most agreed that it would be hard to prove that it was likely to cause immediate lawless action, or that it was directed to. The reason was that the president's speech was incoherent in the sense that it both called for and didn't call for certain actions, and was vague. And so a court may look at that and say, well, was it clear that it was directing or not directing if the rhetoric shifted over the course of the speech? And therefore, was it going to cause immediate lawless action? So you may say that, yeah, they were closer, So the immediacy might be met. But my point was you have to meet 3 prongs, and it's hard to necessarily meet the other ones.
And I think, and you're putting 2 pieces at the table here that we're looking at, which is the way the Constitution works, not just in singularity, but you're looking at the impeachment procedures and
yes. And my point was that they did what they were trying to avoid was, I think, to use a legal term. And so, yes, I think they were trying to suggest something about the rhetoric and inciting certain actions, but without actually referencing incitement itself, which is a legal term that is connected to the First Amendment. And so that this is a bit complex and a little convoluted, but is to say, I think that that's because there was a lot of scholars of the First Amendment say, well, look, it's very speech protective. And the facts here, because the facts are what matter, don't necessarily suggest this was anywhere near a slam dunk case in terms of proving the 3 prongs. So again, I won't say what's right or wrong, because there were people, including we have a podcast on this, which I think students can go to and they can look that up. There were people who say, look, the incitement standard could have been met even under Brandenburg, but the threshold is so great that many, I think most scholars, if not many scholars, would say it's just hard to prove the intent requirement specifically.
And that's really helpful. And also, when looking at these pieces, it's very complex, and there's different parts of the Constitution coming into play. And then what is the common vernacular and what is the legal vernacular too. So great questions, students. Loved how you saw that and kind of weaved it in there, and wanted to really say, how does this play out? And Nicholas, awesome way to say, let me lay out the constitutional facts for you on all sides and all perspectives so you can see how they analyzed it. So thank you so much. That was fantastic. Students, awesome job today. And that was really fun. And I'm really proud of how many cases we got through. So we did it. Awesome. Happy Wednesday. Happy First Amendment Day. So thank you, Nicholas. Thank you, everyone.
All right. Thank you.